Greetings to you colleagues, welcome back to Agora Legis, the platform of legal minds where we discuss legal principles and make them easy to understand for everybody. Today we are diving into contract law 2 where we look at the vitiating factors, and today we shall be looking at the vitiating factor of misrepresentation. We shall look at the definition, the types, we shall look at the elements and define and see whether silence can amount to misrepresentation. Just before we jump right in, I urge you to subscribe, like, and share if you're serious about understanding and appreciating the legal principles. So without further indulgence, I'm Counsel Ben, and let's get the ball rolling. And before looking at the definition, let's first see what is representation before seeing what is misrepresentation. So a representation is defined as a statement of fact made by one party, that we call the representer, to the other party that we call the representee during negotiations that can lead or that lead to a contract. So it is a statement of fact. That is what we call representation. But now we talk about misrepresentation when that representation turns out to be false, turns out to be misleading, turns out to be untrue, and that is where we come with the authoritative definition of misrepresentation. In the case of Fred Nwagaba versus Ademusana Kaguma, a case of 2010, the judge, Honorable Justice Wilson Masalu Musene, sustained that misrepresentation is a statement of fact made by a party to a contract that is untrue and that has the object of inducing them to enter into the contract. So as such, the nature of a misrepresentation is it is a vitiating factor that will affect the consent of the parties to the contract as it is provided for under section 12 of the Contract Act, section 12D of the Contract Act, cap 284. It was further held that it is immaterial whether it is just a statement that is untrue, even if the maker of that statement believes it to be true, or it can even be by conduct that you innocently push someone to believe or to rely on certain material facts that and that person enters into a contract, a binding contract, and it is going to be considered as misrepresentation. Members, after understanding the nature of misrepresentation and the meaning of what we call misrepresentation, we are now going to dive deep into it and see what are the elements that constitute misrepresentation. What is required for a statement to be taken as a misrepresentative statement? The first one is that the statement alleged to be misrepresenting must be a statement of material fact. So it can be made in writing, it can be made orally, or it can even be made by conduct. For example, in the case of Eddington versus Fitzmaurice, directors of a company in this case went on and borrowed money and represented that they want to use it for improving the company's building, whereas they had misrepresented, and the true intention was that they wanted to use it to pay debts. So the court held that such statement was of material fact and was held to be a misrepresenting statement. The second element here, members, is that the statement that is alleged to be a misrepresentation must have been made by a party to the contract or their agent. If a statement is made by a third party that induces someone to enter into a contract, and the person who made that statement is not even a party to the contract or an agent of one of the parties of the contract to the contract, that statement is just a mere puff from an outsider. This brings us back to the doctrine of privity of a contract, where we saw that privity of a contract means that the contract is only binding and rights and liability arise to only people who are concerned by that contract to mean the parties and beneficiaries and people who are having legal rights and liabilities under that contract. So here, for example, in the case of Headley Buying and Company Limited versus Heller and Partners, the statement of the agent about the financial status of the defendant was taken to be a representing statement, even though the case did not end in favor of the claimant. This is just to show how a statement has to be made by either a party or their agent. The third element, members, is that the statement alleged to be a misrepresentation must have been made before the time or at the time of the contract. A post-contractual statement is only a mere information that cannot be binding to the contract. For example, in the case of Roscoe versus Thomas, we have discussed this case in our previous videos, and the fact that the statement of the sound mind of the horse was made after the sale or after the contract was concluded, it automatically made that statement not to be a valid statement, or let's say a binding statement under that contract. Why? Because the contract was already made, and after the time of the contract, any other statement won't have legal power or legal value under that particular contract. Fourth position, members, the statement alleged to be a misrepresentation must have induced the other party to enter into the contract. The other party must have relied on that very particular statement to enter into that contract. Otherwise, it would not render the contract voidable, as it is stated in the Contract Act. Section 15, subsection 3 of the Contract Act, Cap 284, is to the effect that fraud or misrepresentation that does not induce the other party to enter into the contract does not render the contract voidable. And it was enforced in the case of Jeb Fasteners Limited versus Max Boom and Company Limited. Members, there is something that we have to pay close attention to. We have to know how to differentiate a misrepresentation from a mere statement of opinion. When a statement is not a statement of fact, but is only a statement of opinion, someone giving his opinion about something, that statement, even if it is false, cannot amount to a misrepresentative statement, as it was seen in the case of Bissett versus Wilkinson. Mr. Wilkinson, the vendor of a farm, was asked, "How many sheep do you think your farm could contain?" And he declared in his judgment that his opinion is that the farm that he is selling would contain 2,000 sheep, and it turned out that it could not. But in fact, the farm had never contained, or he had never farmed sheep from that particular farm, and the court held that it was just a mere statement of opinion and could not amount in any case to a misrepresentation or a misrepresentative statement. Now comes the big question, members. Does silence amount to misrepresentation? Well, in fact, the general rule is that silence does not amount to misrepresentation, and Section 14, subsection 2 of the Contract Act, Cap 284, is to the effect that fraud or silence cannot amount to fraud or misrepresentation in normal sense. And this is upheld in Section 15, subsection 2, where it said that if the representer keeps quiet or keeps silence, and the representee by normal diligence had means of finding out the truth, silence can never amount to a misrepresentation. However, to that general rule, there are three major exceptions, and the first one is silence can amount to misrepresentation where A party has made a false statement believing that it is true, but later on discovers that it was not true, that it was not accurate. He has the due, he has the obligation to go and disclose the truth before the other party relies on it, on the statement to undertake any legal action. For example, in the case of With versus of Flanagan, a doctor had made a statement about his income, but later on he fell sick and did not disclose the fact that the sickness that he had affected his income for a long period of time, and the court held that his silence amounted to misrepresentation. The second exception as to silence amounting to misrepresentation is when there is a statement that is half true. So initially, everyone is entitled to keep quiet about any material fact, but once you have chosen to speak part of the fact, you are now under the obligation to disclose every material fact regarding that statement that was half true, as seen in the case of Dimok versus Hallet. Thirdly, members, we have contracts of uberimai fidei, or otherwise called in English contract of utmost good faith. So here it is a contract whereby one person or one party to the contract has all the knowledge about the contract or about the implication of the contract, and the other party has no material knowledge about it. So this other party that has knowledge about it has the obligation to disclose each and everything to the other party. Let's take just a banal example. For example, you guys who are literate entering into a contract with an illiterate person, a farmer from the village, to buy his land, you have to tell him each and everything about the process, the legal implication of that contract, and anything not disclosed amounts to a misrepresentation as to silence. And after seeing, members, how silence can amount to misrepresentation, we're now going to look at the types of misrepresentation. So we have mainly three main types of representation: fraudulent misrepresentation, negligent misrepresentation, and innocent misrepresentation. Fraudulent misrepresentation, what do we call fraud? Fraud is one of the biggest vitiating factors that can vitiate a contract, and it was defined in the case of Derry versus Speak. So fraud is willingly misleading the other party in a clear statement that you don't believe to be true. That is what we call fraudulent misrepresentation. Here, the party misrepresenting has knowledge of the truth of the falseness of that particular statement. The party intended to mislead the other party to enter into a contract fraudulently, and he does it recklessly. So that is what we call fraudulent misrepresentation. Following, we have what we call negligent misrepresentation. This is a statement that you don't believe to be true, but without intention to mislead, you just make it recklessly, and that is what we call negligent misrepresentation, as we saw in the case of Headley Baring and Company Limited versus Heller and Partners Limited. Lastly, we have what we call innocent misrepresentation. Here, the party that is making the false statement believes it to be true. With good faith, he gives it in the negotiation leading to the contract, and as we saw it is anyway amounting to misrepresentation, however innocently made. And as per the legal effect of misrepresentation in a contract, it renders the contract voidable at the option of the party who was misrepresented. This means that the innocent party is the one to decide whether they are going to void the contract, whether they are going to carry on with it or not. And that is it for today, members. We have seen the law on misrepresentation under contract law. I hope you have appreciated the principle. I hope it has been helpful to you. And if you're serious about learning and appreciating the legal principles, I urge you to like, subscribe, and share to your colleagues, to your class groups. And do not hesitate to join the WhatsApp group. The link is below down in the description. And we will be glad to continue appreciating together and learning together. It is always Counsel Ben at Agora Legis. Thank you for watching.